Hello and welcome to the Wire Talks. I'm Sidharth Bhatia. Last week, the Supreme Court granted bail to five students and activists in connection with the Delhi riots case of 2020. But bail was not given to two others in the same case, Umar Khalid and Sharjeel Imam, who have also been in jail, Tihar jail, for 5 years. They are still waiting for their trials to start. A few days later, Ram Rahim, the chief of the sect Dera Sacha Sauda, walked out of jail for the 15th time after he was granted parole for 40 days. He is serving a 20-year sentence for raping two of his disciples. The newly elected Mayor Zoran Mamdani of New York, Zoran Mamdani, has written a letter of solidarity to Khalid, and a group of senators and congressmen have expressed concern over the prolonged pre-trial detention. Is jail, not bail, the new norm? That is the question that has been asked by some experts. Why has the Supreme Court not granted bail so far? It is the same court which had once said that prolonged jail violates personal liberty. With me today to explain and analyze this is Sarim Naved, a litigating lawyer who practices in Delhi and handles cases both civil and criminal at the trial courts as well as the constitutional courts level. Sarim Naved, welcome to the Wire Talks.
Thank you. Happy to be here.
First of all, please explain bail to us. What is the circumstance? What are the circumstances it is given?
So, bail has always been contingent in Indian law and in the UK English common law that Indian law is based on the nature of the offense. If the offense is considered less serious, and generally how we as criminal lawyers express that is in terms of the punishment provided by law. If something is punishable by 1 year, of course, it's not very serious. By up to 7 years, it's considered slightly more serious. More than 7 years, slightly more serious. The highest being life imprisonment and death. The idea behind bail is that you should not suffer while you have the presumption of innocence in your favor, which every under trial does. What has happened over the last couple of decades, starting from the 1980s, is that there have been special category of cases, starting from the old TADA, the Terrorism and Disruptive Activities Act, going on to POTA, the Prevention of Terrorism Act, and then the UAPA. These acts, I'm not going to go into the rights and wrongs of it. It's just a matter of fact that Parliament in the 80s felt that a certain category of under trials, despite having the presumption of innocence in their favor for the purpose of the trial, which means that the police and the prosecution, the state still has to prove the case fully against them. There is no relaxation in that standard of proof. However, while the police and prosecution are doing that, Parliament decided that for certain categories of offences, namely terrorism, you should not be allowed out on bail unless you show to the court that your incarceration, your custody is absolutely unjustified. The normal rule of bail, not jail, was reversed at this point. Now, in the earlier iterations of these anti-terror laws, there were sunset clauses. What are sunset clauses? Which said that there's a time limit. I forget now what the time limit in the 80s was, 1 year or 3 years, and after that, this restriction stops applying. This restriction was later brought into the Narcotics Act as well, NDPS Act, and then later, famously, into the PMLA as well, the Prevention of Money Laundering Act. When the Prevention of Terrorism Act was repealed in 2004, a lot of its provisions were incorporated into a law called the Unlawful Activities Prevention Act, which had been on the statute books for more than 3 decades by that time. The UAPA, of course, then was a very little known law. It was used to ban organizations which the government felt were carrying out unlawful activities. The RSS, when it was briefly banned post Babri Masjid, was under this act as well as other organizations. So when the POTA provisions, the Prevention of Terrorism Act sections regarding terrorism, were incorporated into the UAP in 2004, the restriction regarding bail was actually omitted. One more pernicious aspect of the anti-terror laws used to be the use of police confessions. Under general criminal law, most people may not know, every lawyer would know, the whatever the accused says to a policeman is not admissible in law. It is only what the accused says to a judge that's admissible in law. Regardless of what's said to a policeman, the police have to prove their case fully. They cannot simply say, "Oh, he told me this, so convict him." The terror laws, TADA and POTA, included a provision where a police officer of a certain rank could record these confessions. And of course, they claimed that in every case, these hardened terrorists would go and just confess. Now, in some cases, of course, that was absolutely laughable. So that was also removed from the UAP in 2004 when POTA was repealed and the terrorism sections were incorporated into the UAPA. In 2008, after the Mumbai terror attack, the government felt the need to respond and the UAPA was further amended. And then this restriction on bail was reintroduced into terror law. Although thankfully that restriction against police confessions was maintained. Because if that had been brought in, you can well imagine in every case the police, the NIA was also incidentally set up in 2008 only after the Mumbai terror attacks. All these organizations, the investigative agencies would have claimed that every accused has admitted to every crime.
So
Now,
no,
this is where
so
we are.
if I may, we'll expand on this in a minute. But if I may, I think I gathered from what you said also that ultimately, despite the heinous nature of the crime, despite the fact that it may be terrorism, prima facie,
Yeah.
isn't uh, isn't there generally some sort of understanding that a criminal, an accused, may be actually prima facie not guilty, never mind that he confessed and all that, or he confessed under duress, maybe. Isn't there some presumption, and isn't there, you mentioned that there was a hard time limit. Uh, isn't 5 years beyond that time limit, or is it less than? Can you just throw some light on that?
So those were clearly more enlightened times when these limits were there in the law. Right now, there is no such time limit in the law, which is why the Supreme Court, at some point of time in 2017 and 18, saw the trend where the investigative agencies would just keep trials pending, right, and think that there's a restriction on bail, so we won't let you out. And that's when, in a case called K. Najib, the Supreme Court first said that regardless of the restriction under law, simply by dint of the delay in the trial, you have rights under Article 21 of the Constitution that you should be let out on bail. So, sidestepping the entire issue of restriction on bail and whether the prima facie case or not. As I said, the presumption of innocence is available to everybody. It's only in very limited cases, like under the Negotiable Instruments Act, check bouncing, where the presumption is rebutted. Of course, those are not a very serious category of cases. Supreme Court itself has said those are basically quasi civil cases. In any civil criminal case, you know that the investigative agency has every power, and the accused are quite powerless, right? They face investigation, and then they, depending on the quality of legal assistance that they have, which may vary from case to case, region to region, court to court, they may not be able to defend themselves. So that's why, to balance this power, this presumption is never reversed. Only for the purposes of bail is it said that you have to show that there's no prima facie case against you, and because that was being misused. That's why the courts came up with this reasoning that just on delay, if the delay shocks the conscience of the court. So there is no hard limit. There's no set timeline. That's where we are, and that's where the law stands right now.
So, in that sense, one may ask, why were these five others given bail?
So that's the thing, see, because it's all discretionary, right? One thing that
Not
most of
discretionary, sorry, discretionary on whose part? The police and
the
the
courts,
trial. Oh, the courts. Okay.
the courts part. So that's why a lot of us, defense lawyers, prosecutors, also people concerned about criminal law, about procedure, we have been demanding a law on bail or a bail policy. Right now, for many categories of cases, the discretion has been taken away by the Supreme Court itself. Around 10 years ago, they came up with a judgment saying that if you are being accused of an offense punishable by 7 years or less worth of imprisonment, you should not be arrested at all, unless there are very grave reasons that you are going to run away tomorrow, you have threatened a witness, you have hurt a witness. So that category of cases, it suddenly the police's discretion was taken away, and even the judiciary's discretion was taken away to a large extent. Now, in those cases, you don't usually see arrests, including, of course, the Anish Kumar also concerned Section 498, a marital cruelty. So the discretion was taken away by the Supreme Court for a reason, because there's a wide variety of judgments. On the same facts, one magistrate would give bail, one would deny bail, one session judge would give bail, one would deny bail, same for the High Court and Supreme Court. Now, for anything more than 7 years, punishable by more than 7 years, the discretion is still with the judge. Somebody comes out in 2 months, somebody in 2 years, somebody in 8 years. It's justified by saying that if somebody has done something particularly horrible, we can't let them out on bail. Answer to it always is that until you have the trial, until you have the full inquiry, how do you decide that? Now, this actually exposes a very deep systemic issue that we face. Why are our trials taking so many years? Right? If you say that I'm not going to give you bail, finish the trial in 2 months, 3 months, 6 months, 9 months, whatever it is, a reasonable period of time. But the attitude of the police and the prosecution in these cases is the same as in those non-serious cases. See, if somebody is out on bail, you can investigate for 3 years if you want, right? But keep a trial going for 10 years. Of course, it's inconvenient and a bit of a pain for that person. But at least he's out, he's living his life, living a professional life, personal life, everything. In these categories of cases which are supposed to be so serious that one cannot be let out on bail, there is no corresponding responsibility on the police and prosecution to move faster. Right? So they can behave in the same way as they do in the non-serious cases, saying that it has taken me 3 years to investigate. It has now I'm going to start arguments on charge in 6 months. I will bring 4 witnesses per month for the next 8 years. So that is where the systemic problem really comes to the fore.
And the courts have no, or have there been instances where the courts have told the investigating agencies, come on, get on with it, you're taking just too much time?
Absolutely, yes, in many cases. In many cases, especially in the UAPA, when the courts feel uncomfortable granting bail, the directions are for a day-to-day trial, which actually, as per the National Investigation Agency Act, is the rule for every UAPA case, but is hardly ever done. And you can't even blame the courts for that, because the courts are overburdened, right? It's not that the judge is hearing only one case. The judge is hearing many cases per day. They're in bails per day. They have to write orders. They have to record evidence. It's a systemic failure. Okay, right. Terrorism is a serious offense. Agreed. There are some people who are there who are extremely horrible. Agreed. But this system fails completely if your judicial system, if your system of justice treats the prosecution with kid gloves and the accused very harshly. The side, we take litigation simply as two sides. It's an adversarial system, right? The side which has all the power, which is the state, which is the government, the police, the prosecution, all the resources, all the powers under the Criminal Procedure Code and now the Bharatiya Nyay Suraksha Sahita, Nagrik Suraksha Sahita and Bharatiya Nyay Sahita. They are given every kind of leeway that one person who is in custody, we don't know whether he can even afford counsel, we don't know how aware he or she is of their rights. You transfer the burden onto that person to answer everything that this incredibly powerful litigating adversary can bring against them. And that makes absolutely no sense. And which is what gets us into this kind of a morass where we are out there, looking for justifications as to why some people are given bail, some are not given bail. The simple answer is because the discretion exists with the judge. The judge feels bail must be given, he can give bail. If not, then the judge can decide not to give bail.
There is a possibility. I don't say that may be the case. You argue, you suggested that the courts uh, are overburdened, and so they may not have the time, and also the entire system, perhaps, let's say the investigating agencies, the police, the court itself may be inclined in a particular direction. Could there be a and I use the word very, very discreet, very carefully. Could there be a political element to the whole thing?
Well, lawyers always suspect political elements and other elements in every case that we lose. The way the current government behaves, yes, a political element cannot be ruled out. We are all following the Mamata Banerjee ED fracas. Clearly, a political element there. Whatever the judgment of the court is, it seems to be very clearly a political argument at a certain level. A legal argument, of course, exists at another level. Now, a case like the Delhi riots case, now I'm not giving certificates to any previous government or previous system, but regarding terrorism, there used to be an understanding that unless there is a certain threshold crossed, which was usually in terms of weapons used or some particularly nefarious intent, you did not invoke these laws. The Delhi police have done in this case is said that look, if your words are extremely disturbing, we can invoke these charges against you. Now, the law, majesty of the law is a very strange thing, right? The law just has to be uniform to be majestic. It does not have to be right. The fact is that these young people, the two who are especially who are currently in custody, Umar and Sharjeel, they are supposed to be given certain speeches. The others, one distinction is that they didn't really go around giving speeches. You're saying that these speeches were of such virulence and such potency that they caused the Delhi riots. Now that is a leap of faith, a leap of imagination that should ordinarily never be allowed under the law. It was never allowed. The fact that this kind of an argument is being countenanced now is certainly a testament to the fact that perhaps the Overton window has changed or our levels of tolerance have changed. So I'm not going to say that the political element, but yes, these are things that perhaps in an earlier time, the same Supreme Court of India would have not considered terrorism at all. Even now, to be fair to the court in this case, they have said that we are only opining for this purpose of bail, and none of it will bind the trial court in framing of charge or in the final adjudication in any case. But the fact remains that yes, they have given a prima facie understanding that these charges do amount to terrorism.
But his speeches, from what one has heard, hardly call for any kind of violence or anti-India, anti-national kind of, rhetoric. They may have been, we don't know, but so surely everyone can see that or hear that.
Well, yes, as there are a couple of famous cases from the 90s where somebody said Khalistan Zindabad and somebody made some statements which were actually calling for violence, including the Khalistan movement, and the Supreme Court has said, look, this doesn't amount to terrorism. Our understanding of civil liberties also shifts from time to time, right? I mean, it's not only India, worldwide. There are things that are criminalized now, things that are tolerated now, which would not have been tolerated even 20 years ago. So, yes, you cannot never take that political element out of interpretations because ultimately we are all a product of the times that we live in. And when there is discretion, when you don't have a policy regarding bail, when you don't have laws regarding bail, and I'm saying this again and again, of course, many people will say that you're copping out and that that what happened is very unfair and you're not calling a spade a spade. See, the system works in a certain way. One thing I will say is that in India, and I see the responsibility as a lawyer, as somebody who's concerned about civil liberties and about the procedures, due procedure in India, we are never concerned about the procedure. We do not care what happens in the magistrates court in the Mufassal town, right? We don't care what happens in the sessions court. These kind of test cases are very important, yes, because there is the public eye on. But the fact is that people have been in custody in absolutely non-serious cases in this country for many years. Even in UAPA, there are people who have been in custody for longer periods. And UAPA, I believe, is mostly used in Jharkhand and Chhattisgarh and these the Maoist affected areas. Now, when we don't care about how the cop deals with the citizen at the level of the police station, at the point of arrest, how the magistrate deals with the bail application, how the magistrate understands civil liberties. See, one thing I always find is that most of the accused, especially the poorer ones, they have no understanding of this procedure of the courts, right? Something will happen, the judge says something, I will reply something, the lawyer replies something to that. These guys are absolutely clueless what happened. They ask you what happened, and they will say, okay, I'll take your word for it, and they'll go off. Often, legal assistance itself is quite wanting. Often, the judge's understanding of civil liberties, the judge will not be aware of the latest developments or even the older judgments. A lot of it happens because there is an inherent sense of fairness and unfairness in different cultures, and that differs from what the law says. That you would abuse so and so, which is no crime under Indian law, right? But people have been arrested for abuse. So yes, there is a absolute political element. On the other side, we have to really start working on policing at the basic level, the judiciary at the basic level. The UAPA, yes, is a particularly stringent example, but the UAPA cannot be improved in isolation. People, if they are in custody in simple cases for many years, in Jaunpur and Bhojpur and Jabalpur, when you go to them and say that, look, but UAP is a particularly horrible law, that chap spent 5 years in jail. They say, oh, this chap spent 7 years in jail in some, murder case or some assault case or something. So these conversations have to start. The outrage is, I think, extremely timely. Yes, applied to this case, but also understand that there is a much larger issue that if let me do a thought experiment. If Umar Khalid and Sharjeel Imam had been given bail last week by the Supreme Court, would that mean that everything is hunky dory? No, it certainly does not. So we really have to start thinking of these systemic issues as well. Otherwise, on these, we will have examples like this which are egregious, and there will be many more such egregious examples which we are not aware of.
Well, in the at the city civil courts and the small courts, people can be inside for the most trivial crimes, a pickpocket, etc., simply because the lawyer doesn't know how to argue, or he doesn't turn up, or the judge doesn't turn up, and
Yeah.
they come out for the hearing and they're sent back. So yes, you're right, but the fact of also remains that Umar Khalid and Sharjeel Imam, have become cause célebres.
Absolutely. And cause celebrities have their role to play. What all I'm saying is that we shouldn't, as we often tend to do, which I feel, I may be wrong in that. In my 18 years of practice, I feel that we often stop at the cause celebrities. Uh, the kind of debate, so a long time ago, I did a lot of research on obscenity laws in the United States. Now, what I found was very interesting. Most of the obscenity laws were overturned by the Supreme Court in the US and other courts. Why? Because people deliberately broke the law. They asked a moral question of the Supreme Court that this is my freedom of speech. Will you punish me for it? People put themselves at actual risk, actual arrest. And then the moral question was asked and the moral answer was given. So these questions have to be asked at every level, every day. Let us not ask it for 2 days and then forget about it. There will be many more people in every state capital, in every high court. There will be many such cases in every trial court, civil court. All I'm saying is that it's not particularly productive to go in that sense on a case by case basis. The fact is that this case has, in a very stark sense, revealed a great systemic injustice that is going on every day, which has to be addressed. The lack of a bail policy, the lack of a specific law regarding bail, the lack of facilities for quick and speedy trial, the lack of accountability for the police and the prosecution in not carrying out the duties in a speedy manner. All of them have to be looked into and all of them have to be addressed ASAP.
So, Sarim, there is a difference between bail and parole. I realize that. But Ram Rahim, who's a religious chief of sorts, has been convicted of two rapes inside his dera of his disciples. And he has been given parole, that means freedom to step out of his jail for the 15th time. He's convicted for 20 years and he has been given bail to step out. He's been given freedom to step out for the 20th time. Now, I realize these two things are not kind of connected or related in any way. But what kind of perception or message does this send that he has the ability, he still has retains a following, he has the ability to rouse his followers who must be happy to see him back.
Yeah.
What kind of messaging does this send?
It was once told by a lawyer in Chandigarh that when Ram Rahim post conviction appeared in some other case
Hmm.
before the judge got up and did pranam to him. So clearly he does uh, retain that following that he always did. And see, parole is an executive decision. It's taken by the state government, not by the judiciary. As you said, it's a different issue, but in a sense, it's the same if you look at it politically. It shows our tolerance, our moral tolerance is extremely questionable. Speeches, no matter what you think about them, can never be as harmful as a sexual assault, as a rape. The fact is that there is no outrage against the parole, popular outrage. Of course, there are certain people who do speak up about it. Many people speak up about it, but clearly the government feels that they have much more to gain in terms of public support by releasing this person rather than keeping him in custody. On the other hand, the government also feels that keeping Umar Khalid and Sharjeel Imam in custody is perhaps more useful to them than these two outside and free. One more aspect regarding this case was this bail to these five people was the onerous conditions put on them that they will not speak about the case, which is fine, that they will not make any posts on social media. Now, these are somewhat unprecedented conditions. I personally don't agree with them. But again, as you said, ask the question whether there's a political aspect to it. I wouldn't say it's political, but it's a sign of the times that we are living in. That these conditions, which would perhaps have been considered extremely unreasonable even 10 years ago, are now increasingly common.
The accused, some accused who were let off in the Bhima Koregaon case also, uh, some are still in, but some
Yeah.
who were let off on bail, there were a lot of onerous conditions put on them.
Yes.
So yes, they are a sign of uh, sign of time, the times we live in. As you also pointed out earlier, that the way the state and perhaps the judiciary and the people, society in general, looks at certain things changes from time to time.
Yes. Absolutely. Yes. And that
And
may also be a part of the natural progression of how societies develop.
I recall once I was at some kind of event. I think it was a book literature festival or something like that. And somebody on the stage mentioned that was early on, very, very early on, 16 or thereabouts, or maybe even earlier, mentioned Kanhaiya Kumar,
Right.
mentioned him. And
Yeah.
somebody in the audience looking quite like somebody who's of mature age, got up and said, "Please do not take his name. He is part of the Tukde Tukde gang." Now, that was early on, and the concept of this Tukde Tukde gang, those who wanted to break up this country, was already popular.
Yeah.
I was quite taken aback because I said, "Gentlemen, sir, I mean, what do you exactly mean by that?" He said, "No, all these JNU people, they want to break up the nation." Uh,
Yeah.
and mind you, Kanhaiya Kumar later on came out on bail, and
Yeah.
but that sense of the Sharjeel or Umar Khalid or the other five till the other day may still prevail. That these peoples, with their speeches, the very fact of their speeches, dissenting speeches, were somehow associated with splintering this country.
So that's very interesting that you mentioned Kanhaiya Kumar. So apart from the fact, I think all these gentlemen, Umar Sharjeel and Kanhaiya Kumar, they have JNU in common. The In some ways, the foundation of this case can be traced back to that case, right?
Yeah.
It was, I remember when I was told that JNU Student Union President has been picked up. Nobody knew who the JNU Student Union President was in those times. And you thought, okay, something must have happened. They'll produce him to magistrate, he'll get bail. Then, when you're told that it's a sedition case, you're like, okay, I read this law regarding sedition. How can this be sedition at all? What was escalated to the point of sedition in that case has now been escalated to the point of terrorism. So that is the kind of political shift that you see as expressed by Delhi police and their charge sheets. Kanhaiya, if I remember correctly, didn't even say anything in that on that particular
I
occasion.
think he kept on saying Azadi, Azadi, that's all.
Azadi, azadi, exactly. So that is how the the Overton window shifts. Now, ideally, the courts should not shift with the Overton window, but the fact is that at different times, you do get to see a different trend of judicial interpretation. So clearly, that happens. So again, not to get into the issue of what is right and what is wrong necessarily, but clearly the times do impact the interpretation.
But sedition, as we all know, has become somewhat of a phrase that is used fast and loose. So maybe it is now terrorism is a more impact making phrase
Yeah.
since then, because sedition, a student indulging in creating being thrown into jail for sedition may not have the same impact that terrorism does. um,
Absolutely. Because sedition also, if you recall, the Supreme Court has stayed all sedition trials, saying that this current interpretation is being given, we are taking a relook at the law of sedition. So all the sedition trials remain stayed.
so do you think, I mean, one should not speculate, but do you think that because I think, if I'm not wrong, the Supreme Court has said you can now apply for bail a year later. Am I right?
Yes. Yes.
So, is there for a year now they continue to remain in jail? Is
So what
that
the
so?
Supreme Court has said is that there is a category called protected witnesses. These are chaps whose details are not given to the accused, right? Saying that they are so crucial to the case, and we don't want them to be threatened by the accused. So they've said that once these protected witnesses are examined, the relevant ones regarding these two, they can apply for bail, even if that's before 1 year from the date of this judgment. Now, we don't expect the police and prosecution to move really fast and do these examinations. Now, to come to this issue of protected witnesses, which is relevant because it's one of the conditions for bail. See, protected witnesses, and I'm just making this point to show that how the police and the prosecution, they play fast and loose with the law, and they're allowed to get away with things that are perhaps not very sensible. Idea of the protected witness is that this is a person who the accused does not know, who is a witness against him. So you say that, okay, I will not let you know who this person is, but it's very relevant what he's saying. In this case, all the witnesses who are protected, they are saying that something happened in front of me. So and so told so and so in front of me. So and so gave somebody else money. So and so said this in front of me. So who are you protecting these protected witnesses from? The accused knows, right? Accused knows who he said this in front of, assuming what they're saying is true. I know who was there when I said it. I know who was there when I did this. I know who was there when so and so gave so and so money. So it anyway makes no sense. So there are these interpretations of the law which are true to the law in the letter of the law, but not the spirit. That is where the real, the how shall I put it? The more disturbing aspects of the prosecution's behavior come out.
In fact, one of the points that you made, because I've also in the past covered the lower courts in Bombay, and I've seen um, now that there are many cases at the lower, and I'm talking about a city like Mumbai, but
Yeah.
there are many cases one must see in Mufasil areas, or even in the uh, kind of higher courts, in the magistrates courts elsewhere in the country. And so, coming back to that, I think a systematic overhaul. Now, I'm not making a point which is completely, unusual or new or something, but a systematic overhaul of uh, the entire investigative as well as judicial systems. Do you think something like that is likely to happen? There have been committees on this.
It should happen. It should happen because our system is built on the old English system, which they have changed to a large extent. Number one, and number two, this was brought in at a time when there was a much wider gulf between the rulers and the ruled, the governors and the governed. So we have to renegotiate this particular aspect. But more than that, I mean, let me be sympathetic to the police. That chap who does investigations, how much training are they given? In most of this country, the training for the police is abysmal. don't have access to forensics, 24/7 duty, not enough money to. I once I had an accident 9 or 10 years ago, not very serious, and I called the cop because somebody had rammed into my car. And the cop was first quite, irritated. Oh, it was a very hot June day in Delhi. Anyway, after 1 hour, we got talking, got a bit more pally. And that time, the Aam Aadmi Party government had just come in here. This cop said, "वैसे सर ये जो केजरीवाल कर रहा है ठीक कर रहा है वरना पुलिस 10 साल में सड़कों पे होगी. What Kejriwal is doing is right. Otherwise, the police will be on the streets in 10 years." So I said, "What does this mean? You think they're going to rebel or revolt or what?" He said, "No, no, no. What I mean is that look at my bike." I said, "Okay, I can see your bike. The department does not give me the money to fill petrol. I have to take bribes just so I can fill petrol into my bike." So when we talk about reforms, it cannot simply be a paper reform. It cannot simply be a matter of what laws we change the wording of the law. The rule of law, high trust societies, which most Indians want to run away to, and I use the term advisedly. They would love to go, if the doors were to open tomorrow, they would love to go to the West, the Europe, America, Canada, wherever, even Middle East, wherever, Australia, New Zealand, is because there is the rule of law there. Why the rule of law there is because there is dignity for everybody. The cop, of course, America is a bit of an outlier in how the cops treat the citizenry, but even there, your the police's overreach is punished more often than not. The police are taught that you are not above in terms of a hierarchy above the citizen. The police are taught there are certain rules you have to observe. The citizens are taught that you are not below the policeman. You don't have to obey the policeman. There is a system of laws which negotiate your relationship with the police, vice versa. Until we move away from this, and this is, of course, an aspect of Indian society, call it caste, hierarchy, whatever. Almost every interaction you find that between two individuals, you're trying to assess the other, whether I can bully this person or not. Same with the policeman. If there is a sahab who lands up at the police station, English speaking, expensive watch and etc., much better reception than some chap who lands up there with a torn shirt and torn shoes. We have to reimagine, and by don't mean in a theoretical way. We have to work with the head constable, the sub inspector, to see how they view the average citizen. The citizen has to be told that you don't have to be scared. Alternatively, you also have to be to tell the citizen also that you don't have to, it happens often in UP and these states, that beat up this police guy if you can. Right? So this, until we remove this hierarchical aspect of who is bullying whom, if the citizen can bully the cop, then the rich guy gets off. Right? Saying, "Yeah, this is not worth the trouble. If I act against this guy, my job might go." If the cop feels they can bully the citizen, they can put him in jail. What does it matter? Let the judge let him go in like 2 years. What the hell do I care? So, in that fundamental way, we have to work on policing, training for the police, training for the citizens, training for the lawyers, training for the judges. If I am correct, I have it open in front of me, figures from 31st December 22 from 2022 from Tihar jail. As per this, on that date, under trials, 2,426 under trials had been inside jail for 12 to 24 months, 1,284 under trials, 24 to 36 months, 610 for 36 to 48 months, 372 under trials for 48 to 60 months, and above 60 months, that's 5 years, 407 under trials. Now, this is a very large number, and not all of them can be UAPA. Of course, some will be NDPS or narcotics also, but some will be under general criminal law. Until we rethink policing, until we think the justice system from the ground up, we're going to have these problems. See, ultimately, Siddharth, people like you and me are very privileged here. We don't have many of the problems that the average citizen does. We don't have that fear of the police that the average citizen does. We are treated in a different way in every government office, every anywhere we are. I'm not making any highfalutin point here, but the conversation about policing, the conversation about repairing policing, the relationship between the citizen and the state, and that too at the point where the citizen interacts with the state. How DGPs are appointed in states is, of course, important from an administrative point of view, not from a civil liberties point of view. We have to have these conversations on a daily basis. So, and until we start doing that, you know, I don't see things changing, not in the regular cases and not in these exceptional cases either.
I must say that when you were talking about how the police, the constable, or even slightly higher, looks at the man in a suit and looks at the man with the torn shirt, while you were talking about it, the word that kept on jumping into my mind was feudalism. And
Yes. Yeah.
I think, a long social construct of feudalism that passed on to a rural ruler and ruled uh, first under various kings and then under the British Raj, and it was smoothly transited into the Indian system. So, can you imagine that entire? Plus, there are other hierarchies in this country. If
Yes.
you can just put it all together, you can imagine that this is not going to be an easy change. Uh,
Yes, I completely agree. But
um,
just to break in there, sorry, I often find that's where we lose the moral argument, right? If you tell somebody in UP that, oh, isn't what's happening very horrible? They say, what's happened is horrible. Police, they come in and they beat people up while arresting. That chap says, okay, but they beat everybody up. Isn't that the police's job? See, until you kind of try to break that relationship between the ruler and the ruled, nothing will change because a citizen who is scared is not a citizen.
yeah. Well, this has been a very important conversation because you've taken it from a particular incident to the general, and but uh, it still kind of raises questions about why certain people who are in court are given bail by maybe the same courts that hold back bail to the others, and why um, why certain people remain in jail for a very long time, and not necessarily only because of terrorism, out of because of other things also, or terrorism charges rather. Let me clarify that. So, Sarim, thank you very much for this, if I may say so, an intellectual look at the entire issue.
Thank
Uh,
you. Thank you.
and I say intellectual not in the ironic sense, but in a very important sense, that this is something that goes far beyond the headlines. So thank you very much for doing this, and that was Sarim Naved, lawyer, criminal and civil lawyer, discussing the Umar Khalid and Sharjeel Imam cases and going far beyond that particular headline issue. We'll be back soon with another episode of the Wire Talks. Till then, from me, Sidharth Bhatia, and the rest of the team, goodbye.